we pick up on that breaking news this morning. More efforts to keep Donald Trump off the 2024 presidential ticket. Maine becoming the latest state to find him ineligible to appear on the primary ballot. And the first state where an election official has taken action independently to remove the former president. Secretary of State Shenna Bellows says that she will, quote, suspend her decision as long as there is an appeal to a higher court. Bellows' decision in Maine coming after Colorado's Secretary of State put Trump back on the ballot, saying he is going to stay until the January 5th primary certification deadline, or if the Supreme Court tosses out the ruling. Meanwhile, over in Wisconsin, a new complaint to remove Trump off their ballot is actually heading to court after a petition was brought on by a Democrat activist, and that was rejected by the State Elections Commission. A lot of moving parts this morning. I want to bring in former acting U.S. Attorney General Matt Whitaker. Matt, good morning. Thanks for joining us on this breaking news. Let's start with what's going on with Maine. So this is the Secretary of State there, Shenna Bellows, who has been, we should be clear here, on Twitter, making some very disparaging remarks in the past about the former president. But his lawyers, they want her to disqualify herself. They also say that you can't pull him off the ballot and charge him with insurrection if he wasn't convicted of insurrection. What's the legal side of this, Matt?
Yeah, well, it's good to be with you today, Cheryl. You know, there's these cases where these liberal activists, whether it's in Colorado or now in Maine, are taking action with no intent of it actually sticking, knowing that the law is not on their side. But they're, I mean, to some extent, virtue signaling almost, you know, showing that they, you know, are liberals and they are against Donald Trump and therefore using their little fiefdom to try to prevent him from being president. But, you know, the rule of law is the most important thing here. And obviously, to your point, due process rights for him to be on the ballot, you know, would include that the fact that he's never been charged, never been convicted, never been otherwise even suggested of being charged with this idea of insurrection, and therefore the 14th Amendment, Section 3 doesn't apply. But you know, it's a sad day where a unelected Secretary of State appointed by the state legislature in Maine, you know, abuses her power in order to demonstrate that she is somehow woke.
Well, I want to show, and I mentioned this real quick, I want to show this tweet from Bellows, and this is where the Trump campaign is really pushing back, and his attorneys are pushing back to get him on the ballot, back on the ballot in Maine. And basically in these tweets, and by the way, she's the former executive director of the ACLU, just to let everybody know here, just to give you some context. But basically, she is saying, she in these tweets, basically, you know, said basically that the U.S. Capitol attack was an insurrection. She complained that Trump was not convicted by the U.S. Senate after being impeached by the U.S. House. So she's vocalizing, and this is from, you know, this is January of 2022, so we're going back. Does this disqualify her? Should she step aside when she's making comments like that on X?
Yeah, I mean, she's clearly prejudged the case and decided that this is how she's going to use her power. I mean, I've been calling for more statesmen and stateswomen that actually can take off their partisan hats and do their jobs. And I think our founding fathers are rolling over in their graves right now, seeing how these laws and these, you know, people with their small amount of power are abusing that power and not in the interest of the people. You know, this is a really assault on our republic and our ability of the people to decide who they want to be their president. And I think as Joe Biden continues to weaken and does not look like he's going to make it to a second term, whether not being elected as a second term or just physically not being able to perform. I think ultimately, you know, you're going to see these bureaucrats step in and try to interfere with an election. I just don't think that can stand. And I hope the Supreme Court acts quickly to demonstrate what the law is, and that is that Donald Trump is eligible to be on the ballot in 2024.
That's where this is all going. Just, I mean, if you want to take all of these states and just combine and that, you know, make it easy here, everything's going to the Supreme Court. And then Colorado, now that is actually at this point, you know, pending the appeal to the Supreme Court, it looks like he's going to be back on the 2024 primary ballot in Colorado. But again, they're using this insurrection argument. And I just want to clarify here, just to be crystal clear, I mean, he wasn't convicted of that crime. So, I mean, it seems to me that the Supreme Court has a very clear decision to make here.
Well, and not only that, Cheryl, I mean, the idea of the 14th Amendment, Section 3, applying to Donald Trump, I think is ludicrous. The people that framed that and wrote that knew exactly what an insurrection or rebellion was, and that was the Civil War, where 600,000 American citizens died fighting each other. And, you know, so ultimately, this idea that what happened on January 6th is analogous to that or was somehow intended by the drafters of this and the people that then ratified it in all the states, I think is just an absolute ludicrous legal joke, ultimately. And the people that seriously believe this legal argument, I think, should not be taken seriously.
Okay. Matt Whitaker, thank you so much for getting up early and joining us on the breaking news. Really appreciate it this morning.
No problem.
All right. Happy New Year to you, Matt. We will see you in the new year, obviously.